I'm the big man, attorney Joey Franks with Big Man Law here in Jackson, Mississippi. And today we're changing pace a little bit. We normally have a lot of criminal matters, but we're actually dealing with a divorce child custody issue. And it's a hearing to determine whether or not they're going to have to abide by some of the prior obligations that either they agreed to or the court entered a judgment on one way or another. So, without further ado, here you go.
Is in the matter of David Shorts versus Jessica Sue Shorts, file number 2020-47465 DM. I have Jenny R. Stone, P77883, appearing on behalf of the defendant. All parties are appearing via Zoom. We are here today on plaintiff's objection to the referee's recommendation and order. Both parties petitioned for a referee hearing regarding the issues of child support and parenting time. The referee determined there was no reason to modify the parenting time schedule. The referee did determine that it was appropriate to change some parenting time conditions, adding a licensed driver whom the children are familiar with must transport the children. Parenting time exchanges will continue to take place in Albion. Neither parent will record parenting time exchanges. Neither parent will disparage the other parent or anyone in the parent's household in front of the children. Neither party will discuss enrolling the minor children in extracurriculars with the children without first discussing with the other parent. Neither parent will schedule summer activities outside of their own parenting time without the consent of the other parent. And the parent will forfeit a parenting time phone call made later than 5:15. They also entered a uniform child support order. Mr. Shorts, you objected to everything as you essentially allege that defendant mother is alienating the minor children and you're indigent, so you can't afford support. You did provide, thank you, a very thorough brief. Some of the things I wanted to talk to you about is what is, let me look at your judgment support.
Your Honor, may I add one thing real quick?
Yeah.
So we did file an objection as well. I called and I got a court date of August 19th of 2024 at 9 a.m. We mailed it in on the 26th and I served a copy to Mr. Shorts. In the meantime, he must have gone to the clerk's office, filed an objection, and he got this date. So it's my understanding we have two different dates for objections, but both plaintiff and the defendant have filed an objection.
Yeah, I know that. I was just going through his.
Okay. All right. I just want to make sure
that you,
because we have the different
you
dates.
have an objection that she wants to be able to enroll the children in extracurriculars during the school year. That's your objection,
Yes,
right?
Yes.
Yep,
Just clarification.
Yep. I just hadn't gotten there yet.
All right. Thank you. Sorry.
That's okay. Let's see. So Mr. Shorts, I was looking back at the judgment. Let's see here. Let me find the judgment of divorce somewhere back here. Oh, this is a second file. So, Mr. Shorts, are you saying that there's a clause in your judgment of divorce that the parties be required to leave 50% of their estate to the children?
Yes, there is a clause in our divorce that states that. And at the time I was, I didn't have any future plans of meeting anybody else or moving forward. And now that has happened, because I am still young, I do have a daughter, biological daughter that I have to include in that stuff. And it just doesn't work. That.
Okay. So, Mr. Shorts, I can't go back and change a judgment of divorce.
Okay.
I mean, once the judgment of divorce is entered, it's entered, and that's it.
Okay, so then I'll just leave everything in my future wife's name, and I'll put it in a living trust to where nobody can touch it. That's fine. Because no court can go against those.
And then you said that you are entitled to a jury trial in the issuance of a child support order, and no, you're not. You're not.
So you guys are allowed to go against Supreme Court law? Is that it? because it's under a you can't have something without due process in a jury trial.
So no, none of that's true.
Really? Because I just beat a case and had 2 cases nollied and dismissed under judicial clause. Like, what
Okay.
jurisdiction?
So child support is entered, you had due process, you had hearings, it was entered, you provided your financial information. If you're indigent and not working and you can't afford your child support, the resolution of that is to get a job. So
I am working, but the thing is you as a court do nothing for me. You as a court have failed me miserably. You as a court also told me that the Michigan Child Custody Act is a private act. It's not, because if it was a private act, it wouldn't be on your website through Lenawee County as a handbook. It wouldn't be across the state and every other county as a handbook. You as Lenawee County fail people miserably and don't protect others.
None of that really applies. So thank you. And
then
let's
take it to it. Let's push it to a Supreme Court matter, Your Honor, because
you can do that. You do have the right to appeal this to the Court of Appeals, and you have every right to do that. But
I want this whole case dismissed under judicial bias because you used to be my court-appointed attorney back when I was 17. And I don't feel I have a fair trial through this court. And
Mr. Shorts, I represented more than 10 people a week for a period of 10 years. I may have represented you. I don't remember you. It wasn't on this case. And so there's a 5-year period that has passed. So Mr. Shorts, I'm not going to recuse myself because I represented you so many years ago on a completely different case. So no.
I feel that I'm not getting a fair trial because of it, so I'll turn it into the JTC.
This isn't a trial. This is an objection hearing. And I would grant your request if it was something I was able to grant you relief on, but these are things I can't grant you relief on.
You are allowed.
I have to follow the law.
Okay. Well, so do I, because I've been seeking help because I can't afford it. So yes, I do go to other lawyers and seek help. And
excellent.
Also,
so when you can hire that attorney to do an appeal if you'd like. But so just to make a thorough record, I can't go back and change a judgment in divorce based on the reasons you said. I cannot give you a jury trial on child support. And yes, the referee does have and the referee does have the right to issue a uniform child support order. If you wish to appeal that, feel free. So Ms. Stone, what you're saying is your objection will be heard on the 19th of August?
We were hoping that we would be able to address all matters today because it does deal with sports that start just prior to school.
I object to that. Absolutely not. I had to wait for your guys' stuff that you ejected. It is not for that matter.
So Ms. Stone, all right, Mr. Shorts, Ms. Stone, we'll hear it on the 19th. All right.
Thank you, Your Honor.
All right. Thank you, Mr. Shorts and Ms. Shorts, Ms. Stone.
Okay, wait a minute. Why am I being dismissed? You haven't even gone through my whole entire case, so you're just going to go ahead and dismiss it and not even go through the whole process.
Those are your objections. That's all I received.
Really? Because on the back of that, there's a quorum non-judice, and you haven't even spoke about that.
A what?
Quorum non-judice. It's in the packet that you have, Your Honor, and you haven't even spoke on it.
Because it doesn't apply. Mr. Shorts, we're done for today. Thank you. Okay. Bye, Ms. Stone.
Thank you.
So you've seen the video, and this guy, he doesn't make a lot of sense to me, because either he entered into this voluntarily or the matter was tried in front of a judge. But then he gets upset because he doesn't have a jury trial over this, and jury trials in divorce are pretty well unheard of, at least around here. Mississippi has what they call a chancery court that handles all that, and it's a court of equity. There are only 2 other states, Tennessee and Delaware, that have those kind of courts. And some other states have some form of them, but they're connected to other courts. Our chancery courts are standalone courts. And there are circumstances where you can get a jury trial in a chancery court, just not for this stuff. Not happening. So really interesting to hear him arguing about that. And then he smarts off with the whole, I'll go set up a trust, this, that, and the other. And why you would ever tell anybody that you are about to end run them, if you can, is beyond me. If they're putting the screws to you and you think you can sidestep them, go sidestep them. You don't have to tell them about it. Really interesting that he did that and goes with the nonsensical stuff. And what he is talking about, I thought he was saying forum. Let me see what it is. Forum non judice. No, he's saying quorum non judice. And I looked that up, honestly, because that's Latin. Yes, I know some Latin terms, but law books are not written solely in Latin. And again, we're getting into the sovereign citizen thing. He is arguing that the court lacks jurisdiction, which is really interesting because he's been here a couple times. It's pretty clear. So it doesn't make any sense to me. And then he pulls one that is swinging for the fences. He wants the judge to recuse herself because she represented him when he was 17. And this is actually something pretty common, and it's a misconception among even attorneys, that just because you represented somebody in the past that you can't go against them, you can't judge them, or anything like that somewhere down the line in the future. And that's just not the case. If it's something completely unrelated, if I represent somebody on a criminal matter and then years later I'm suing them in a car wreck matter that has nothing to do with their prior criminal one, then yes, the rules of professional conduct do let me sue you, even though I've represented you in the past. And what's more, it happens more often from the defense side. When I say defense, I mean civil defense, where they get waivers that say, hey, you've represented us on these matters. We understand that you do insurance defense for everybody, and we're not trying to box you in, so you can represent other insurance companies that may possibly be going against me in some capacity at some point. So anyhow, it's a roundabout way of getting there. But this guy, he never gets there. Try as he may. Judge shoots him down, and frankly, I think she was a lot nicer about it than he should have expected. It's been fun, as always, and I will see y'all on the next one.